Okay,
So that's good.
all right. Good morning.
Morning,
Calling the
Dave.
case of Kid versus Justin Allen Schwab.
Good morning, Your Honor. Mark Webb on behalf of the people.
All right. And Mr. Rowe is not available this morning. You are Justin Allen Schwab.
Yes,
All right. And you're here in a contempt of court charge for failure to appear at an arraignment on March 16th of 21. Since your attorney's not available, we will just enter not guilty pleas to the charge on your behalf. Bond was set at $50,000 cash. We're going to leave that as is, and we'll notify your attorney that you've been picked up, that you're in the jail, and that he can contact you and he can file a motion to reduce bond at any time. All right. Anything further from anybody?
No, thank you.
Okay. We're in recess. Thank you. All right.
Mr. Schaub, you're done for the day. Thank you.
All right, see you guys at 10:30.
Okay, thanks.
Yeah, bye.
Do you have the case number for Shaw?
Yeah, 21-6584.
All right. 55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good morning, you may be seated. Calling the case of Justin Bigford versus Benchley Brothers Incorporated, file 21-900084-NZ. Would counsel identify for the record, please?
Yes, Your Honor. Good morning, Victor Mastromarco, on behalf of the plaintiff.
Good morning, Your Honor. Linda Ryan on behalf of defendant.
Good morning. Today's the date and time scheduled for a pretrial conference in this case. I believe the matter would be scheduled for a jury trial. Is that what each of you still wants?
Yes, Your Honor, for plaintiff.
Thank you, Mr. Mastromarco. I assume that's what you would like as well, Ms. Ryan?
We do not object, no.
All right. Are the pleadings sufficient from the plaintiff's point of view, Mr. Mastromarco?
Yes, the only thing that there may be as I was looking through this morning, there is a comp claim that's going on at the same time as this claim. And because they cut him off from workers' comp, he had been injured before this happened. And they just cut him off. And there may be a retaliation claim in there that I just saw this morning. Would I be asking too much for 30 days to amend the pleadings?
Sure. So the pleadings will be left open for 30 days.
Your Honor.
Yes, ma'am.
Just so everyone is aware, decisions regarding comp are not made by Benchley Brothers, but rather their third-party provider. So if Mr. Mastromarco wishes to add or amend his pleadings, he's also going to have to add a party because our client has no part in that decision.
I'm not adding a party, Judge. I'm going to add that claim because they're responsible under law for workers' comp. So these people aren't just out there went rogue.
All right, well, thank you, sir. Whatever the legal effect of that is, the legal effect is.
Thank
But
you.
this would be for a possible workers' compensation denial claim.
No, it would be for retaliation by the employer under the Workers' Compensation Act.
Okay. Well, I don't know, that might be a novel theory, it might be an appropriate theory under the facts, but in any event, we'll leave we'll give you 30 days, we'll give each party 30 days to file further pleadings. And I would ask that each of you exchange the names and addresses of your known witnesses, other than expert witnesses, within the next 28 days. And I would ask that you also during that same time period exchange or make known to one another your known exhibits and the rest as they become known to you. And apart from that, Mr. Mastromarco, does the plaintiff expect to call any expert witnesses?
If we did, it would only be simply an economist, Judge. And so we normally do that, but then, so I would reserve that right if that's permissible for the court, with the court. I can give them.
To name whom as an expert witness?
I'm sorry, I didn't hear you.
Who was it you indicated might be named as an expert witness?
Okay, yes, I usually use this Dr. Frank Stafford out of University of Michigan. So that's who we're gonna, Stafford.
All right, can you name any expert witnesses within 28 days of
Yes.
today, Mr. Marco?
Yes, Judge.
And thank you, sir. And Ms. Ryan, would you need more than 28 days from today to name any expert witnesses, ma'am?
Yes, we would. And the reason being that if Mr. Mastromarco is adding a retaliation claim, we'll likely have to call in an expert witness regarding occupational ability to do the job. I have, at this point, not contemplated who that might be. So I would ask for about 21 days after the 30 days to amend.
Okay.
To give us
thank you,
time to do that.
All right, we'll say 60 days from today then for the defense to name any expert witnesses. And I would ask for trial briefs at least 14 days before the trial. I would also ask that any proposed jury instructions and any proposed verdict forms be submitted at least 14 days before trial. And further, that any proposed jury instructions be typed in full, not merely cited by number. We'll leave discovery open as long as it doesn't interfere with the trial. And how long do you think it would take to try the case, Mr. Mastromarco?
Like maybe 3 days maximum.
Would that be for the plaintiff's part of the case or the entire case?
I couldn't see it going more than that. I mean, it's a very simple factual pattern, Judge.
Okay, would you agree, Ms. Ryan?
Yes, Your Honor.
Thank you, ma'am. And when is the earliest time the parties would be ready for case evaluation, Mr. Mastromarco?
Within, I'm thinking, 90 days to 120 days. What do you think, Councilman?
I would think 120, again, depending on the need for experts. and who those experts would be, and initial discovery, an opportunity to have initial discovery exchanged.
All right, I could either schedule case evaluation no earlier than September or no earlier than November. Do you have a preference, Ms. Ryan?
And no earlier than November.
All right. And then if that is the case, we're looking at trial date no earlier than January or February of next year. Does that sound logical, ma'am?
Yes, Your Honor.
And do you agree, Mr. Mastromarco?
Yes, Your Honor, whatever the court would choose to do.
All right, thank you, sir. All the claims have been joined other than the possible retaliation claim. Is that correct, Mr. Mastromarco?
Yes, that's right, Your Honor.
And Ms. Ryan?
I'm sorry, Your Honor, I didn't hear what you said.
Apart from the possible retaliation claim, have all of the claims been joined?
Yes, Your Honor.
Thank you, ma'am. Is there anything else, Ms. Ryan, that you would like in the pretrial order?
No, Your Honor.
Or Mr. Mastromarco?
I don't know how the court feels about facilitation, Judge.
I mean, I'm all for it if the parties think it would be productive.
Mr. Mastromarco, are you thinking facilitation in lieu of case evaluation or in addition to case evaluation?
It doesn't matter to me. I mean, I don't care one way or the other. If you want to, quash the mediation and go with the facilitation, that's fine. Whatever the court and you, whatever, if you say that you want to squash mediation, I don't have any problem as long as it's okay with the court.
Which is fine with me if the parties are in agreement.
I would prefer a mediation over a case evaluation.
Okay. And when you say mediation, that would encompass the possible facilitation as well?
Yes, Your Honor.
All right. And you would prefer, and I know some facilitators and mediators, for whatever reasons of their own, tend to prefer to conduct the facilitation or the mediation instead of case evaluation. The lore seems to be that for whatever reason, they think they obtain better success if they don't have case evaluation. At least anecdotally, that's what I've been told. So, will the parties be able to select their own mediator or facilitator?
Yes, from the plaintiff's view, and I've dealt with Ms. Ryan's office before, and I think we've always agreed on someone.
Okay,
I concur, Your Honor.
thank you, ma'am. Then I'll just indicate the parties have stipulated to facilitation / mediation, and will select their own mediator. Thank you very much. Is there anything
Your
else?
Honor,
Yes, Jen, go ahead.
I just wanted to clarify an administrative issue. Our office moved, and I think that the original order regarding today's hearing was sent to our former office. So I'm hopeful that we can ensure that we've got the correct addresses.
Okay.
And the
I will
address
ask-
for, oh, go ahead.
Go ahead, ma'am. I was just going to ask the clerk to make a note of the address you are about to recite.
That address is Jackson Lewis, PC, 2000 Town Center, Suite 1650.
I interrupted you, ma'am. You said 2,000 Pound
Town,
Center?
TOWN,
Thank you. I'm sorry, ma'am. Thank you.
Center, CENTER, Suite 1650, and that's Southfield 48075. Our Grand Rapids office used to be at 61 Commerce, and I think that is where the original order went, and they're no longer forwarding those. Any mail that comes to that address is no longer being forwarded.
Thank you, ma'am. The clerk is indicating she got that address.
Thank you.
Thank you, ma'am. Is there anything else you would like, Mr. Mastromarco or Ms. Ryan?
Not from the plaintiffs, Your Honor. Thank you. Very nice to see you, by the way.
It's good to see you. And
Not from the defendant either.
thank you, Ms. Ryan, and thank you for being here today. We'll be in recess then, and I will ask the clerk to send each one of you a true copy of the pretrial order.
Thank you very much.
Thank you, sir.
Thank you.
Thank you, ma'am. We'll be in recess.
Good morning. Can the person with the phone number ending in 197 identify for the court? Good morning, sir. What's your name?
Jeremy Michael LaPrade.
You said it's Jeremy Michael. What's your last name?
LaPratt, LaPratt.
Thank you. And the phone number ending in 197?
Yes,
And what is your name?
Billy Sue McDaniel LaPratt.
Thank you.
Calling the case of Jeremy Michael LaPratt versus Billy Sue LaPratt, file 21-90025-DO. Mr. LaPratt, do you have a lawyer representing you?
No,
Ms. LaPratt, do you have a lawyer representing you?
No,
Mr. LaPratt, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name, sir?
Jeremy Michael LaPratt.
You may be seated if you'd like, Mr. LaPratt. Billy Sue LaPratt, would you please stand and raise your right hand to be sworn, ma'am?
yes,
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Could you tell us your last name, ma'am?
McDaniel
Could you tell us
LaPratt.
I'm sorry, could you tell us your full name, ma'am?
Yes. Billy Sue McDaniel LaPratt.
Very well, you may be seated if you'd like, Ms. LaPratt. What brings us into court today is that back in January of 2021, the plaintiff, Jeremy LaPratt, filed a complaint for a divorce. After that occurred, according to a proof of service in the file, a copy of the complaint was served on the defendant, Billy Sue LaPratt. Nevertheless, the defendant never filed a written answer to the complaint or any other responsive pleading, which prompted the plaintiff, Jeremy LaPratt, to seek entry of a default. And back on March 12 of 2021, the clerk of the court did issue a default against Billy Sue McDaniel LaPratt. And then the case was scheduled for a hearing on April 6th of 2021, but neither party appeared at that hearing. And the court then rescheduled the matter for today for purposes of possible entry of proofs. Jeremy, from your point of view, have you and Billy Sue LaPratt reached an agreement about how you want to divide up the property and the debts and the other issues in the divorce matter, sir?
Yeah, she took her stuff and we don't have any property to split.
All right. Billy Sue LaPratt, from your point of view, have you and Jeremy agreed on their issues in the divorce?
Yes.
Okay, thank you, ma'am. Ms. LaPratt, were there any children either born or adopted during the marriage?
No.
And are you currently pregnant?
No.
When the divorce is over, Ms. LaPratt, do you want your last name still to be LaPratt?
No, sir. I'd like it go back to just McDaniel.
Could you spell that for me? Is it just MC or MAC?
McDaniel.
And MC, and then is that a capital D?
Yes.
So MC capital DANIAL or EL?
EL.
Thank you, ma'am. Now, is that your maiden name?
Correct.
Is there any purpose of fraud or deceit behind you asking to have your last name changed?
No.
You simply would like your maiden name restored to you, correct?
Correct.
Ma'am, do you understand that unless you ask for alimony or spousal support today, that you can never ask for it in the future?
Yeah, I understand.
Knowing that, are you asking for any alimony or spousal support?
No, sir, I'm not.
Sir, do you understand that unless you ask for alimony or spousal support today, that you can never ask for it in the future, Mr. LaPratt?
Yes, sir.
Knowing that, are you asking for any alimony or spousal support, sir?
No, sir.
All right. Do you, Mr. LaPratt, own any land or houses?
No.
And Ms. LaPratt, do you own any houses or land?
No, sir.
Mr. LaPrat, from your point of view, do you have all of the personal property in your possession that you want?
Yes,
And from your point of view, does Billy Sue LaPrat have all of the personal property in her possession that she wants?
yes, sir.
Ms. LaPrat, do you agree with those two statements?
Yes, sir.
So you have all the personal property in your possession that you want, ma'am?
Yes, sir.
As far as you know, Jeremy has all of the personal property in his possession that he wants?
Correct, yes.
All right, when the divorce is over, Mr. LaPrat, do you want to give up any claim you have to Billy's life insurance, Billy Sue LaPrat's life insurance policies? And also have her give up any claim she has to your life insurance policies?
I don't have any life insurance policies, no.
Okay, so if there were any such policies, you want to give up your claim to hers and have her give up her claim to yours, is that true?
Yes, sir.
Is that what you want as well, Billy Sue LaPrat?
Yes,
And similarly, when the divorce is over, Jeremy, do you want to give up any claim you have to any pensions or annuities or retirement plan accounts or IRAs that Billy Sue LaPrat has, and have her in turn give up any claim she has to any such accounts that you have?
Yes, sir.
Is that what you want as well, Ms. LaPrat?
yes,
Is there anything else either of you would like put into the judgment of divorce, Mr. LaPrat
No, sir.
or Ms. LaPrat?
no, sir.
Mr. LaPrat, you filed a complaint for divorce in this case, is that correct?
Yes, sir.
Now, immediately before you filed the complaint for divorce, had you been living in the state of Michigan for at least 180 days and in Clare County for at least 10 days?
Yes, sir.
Were the things that you wrote in the complaint for divorce true at the time you wrote them?
Yes, sir.
Are they still true today?
Yes, sir.
Has there been a breakdown in your marriage?
Yes, sir.
Has your marriage broken down to the extent that the objects of matrimony have been destroyed?
Yes, sir.
Is there any reasonable likelihood that you and Billy Sue will be able to save your marriage?
No, sir.
As a consequence, then, do you want to be divorced?
Yes, sir.
Very well. Is there anything else you wanted to testify to, Mr. LaPrat?
No.
Ms. LaPrat, do you have any questions of Jeremy?
No, sir.
Mr. LaPrat, do you have any other witnesses you wanted to call, sir?
No, sir.
And Ms. LaPrat, do you have any witnesses you want to call?
No, sir.
Ms. LaPrat, do you wish to testify yourself?
No.
All right. In this case, from the proofs that have been presented, the court does find that there has been a breakdown in this marriage to the extent that the objects of matrimony have been destroyed, and there's no reasonable likelihood this marriage can be preserved. And further, that the other statutory grounds for a divorce have been satisfied as well. A judgment of divorce is granted and the court has signed a judgment of divorce consisting of 2 pages. And the court will file the original judgment of divorce with the clerk of the court and ask her to mail to each one of you a true copy of that judgment for your own records. Thank you both for being here, and good luck to both of you.
Thank you.
Thank you. Have a good day.
You too, ma'am. We'll be in recess.
You can both hang up. I do not have the other parties that are until 10:15.
Thank you.
All rise. 55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good morning. You may be seated. Calling the case of Renee Ann Parker versus Jason Robert Parker, file 21-900078-DO. Ms. Parker, would you please raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name, ma'am?
Renee Ann Parker?
You may be seated if you'd like, miss. Is Jason Robert Parker present? The record should indicate no response. The record should further indicate this case was scheduled to be heard at 10:15 today. It's now 17 minutes past that time. It's 10:32 a.m. by the court's clock, and Mr. Parker has failed to appear. The record should also indicate that the plaintiff, Renee Ann Parker, filed a complaint for divorce in this case back on March 2nd, 2021. According to a proof of service in the file, a copy of the complaint for divorce was served on Jason Robert Parker on Wednesday, March 3rd, 2021 by Deputy Zachary Paisley. Nevertheless, the defendant never filed an answer to the complaint or any other responsive pleading, which prompted the plaintiff, Renee Ann Parker, to seek entry of a default. And back on April 27 of 2021, Deputy Court Clerk Peggy Chaffee entered a default against the defendant. The case then was scheduled today for taking of the proofs, and the defendant has failed to file anything in the file, and he has failed to appear here today. It's now 10:33 a.m. Ms. Parker, did you file a complaint for divorce in this case?
Yes.
Now, immediately before you filed that complaint for divorce, had you been living in the state of Michigan for at least 180 days? And had you also been living in Clare County for at least 10 days?
Yes.
Were the things that you wrote in the complaint for divorce true at the time you wrote them?
Yes.
Are they still true today?
Yes.
Has there been a breakdown in your marriage to the extent that the objects of matrimony have been destroyed?
Yes,
Is there any reasonable likelihood that you and Jason will be able to save your marriage?
no,
As a consequence, do you still want to be divorced, Ms. Parker?
yes,
Were there any children either born or adopted during this marriage?
not by me. I
All
can't
right.
speak for him.
All right, so he might have had a child by someone else, but in
He
any
might have.
event. What's that, ma'am?
I said he may have, I have no idea.
All right, in any event, you did not bear any children during this marriage, and you yourself did not adopt any children. Are those
I did
things
not.
true?
Correct.
And are you currently pregnant, ma'am?
No,
When the divorce is over, do you want your last name still to be Parker?
no,
What would you like your last name to be?
Hughes.
Hughes?
H-E-S, yep.
And is that a name that you have had in the past?
That was my birth name.
All right. So that's your maiden name, is that true?
Yes,
Is there any purpose of fraud or deceit behind you asking to have your last name changed back to Hughes?
no,
You simply would like your maiden name restored to you, correct?
yeah, I'm tired of everybody else's name.
All right. Ma'am, do you understand that unless you ask for spousal support or alimony today, that you can never ask for it in the future in this case? Do you understand that?
I do now. I didn't think I was eligible for alimony.
I don't know if you are or not. You're eligible
Yeah.
to ask, but so
I'm
far
good.
you asked. Okay, so do you understand that if you wanted alimony or spousal support in this file, that you would have to ask for it today, or you would never be able to ask for it in the future? You understand?
Yes. Yes.
Knowing those things, are you asking for any spousal support or alimony?
No,
You don't want to pay any to Jason either, do you?
no,
All right, do you, ma'am, own any houses or land?
not to my knowledge. I don't believe I do.
All right, does Jason own any houses or land?
I believe he does. I just haven't really went and searched out to see exactly, but I do believe he does have others somewhere. What, I have no idea. I put on there divide. I figured that the courts would know what he owned and didn't own, but at this point, Your Honor,
What he owns or doesn't own. I'm not Google. I'm not Jeff Zuckerberg. I'm not Jeff Bezos.
no, I don't want anything.
I have no idea in the world what you own. I have no idea in the world what he owns. Now,
No,
do you want to make any claim for any real estate that he owns or not?
no,
All right. Thinking it through, do you believe that neither you nor Jason own any real estate or land?
true.
Have you and Jason divided up the personal property the way you want it to be divided, Ms. Parker?
Yes,
Do you have all the personal property in your possession that you want?
Yes,
Does Jason have all the personal property in his possession that he wants?
I believe so.
When the divorce is over, do you want to give up any claim you might have to any life insurance policies on Jason's life? And in turn, have him give up any claim he has to any life insurance policies on your life? Is that what you would like to happen?
Give up claim to him?
Yes, ma'am. He gives up any claim to yours and you give up any claim to his. Is that what you want to happen?
Yes,
All right, and similarly, when the divorce is over, do you want to give up any claim you have to Jason's pensions or retirement plans and have him give up any claim he has to your pensions and retirement plans also?
yes.
Now, ma'am, is there anything else you want put into the judgment of divorce?
No, I don't believe so.
Okay, thank you, miss. Very well, then, in this case, from the proofs that have been presented, the court does find that there has been a breakdown of this marriage to the extent that the objects of matrimony have been destroyed, and there's no reasonable likelihood that the marriage can be preserved. And further, that all the other statutory grounds for a divorce have been satisfied as well. The judgment of divorce is granted, and the court has signed a judgment of divorce consisting of 2 pages, and the court is filing that original judgment of divorce with the clerk of the court. And I will ask the clerk of the court to mail you a true copy of that judgment, Ms. Parker, for your own records, and to mail a true copy of the judgment to Mr. Parker as well. Good luck to you.
Your Honor.
Yes,
Your
miss.
Honor.
Yes, ma'am.
I am fixing to go on a trip. Could I come and get a copy of that today at the courthouse?
Yes, ma'am.
So I can come over and get a copy of that right now?
Yes, well, in about 20 minutes would be my guess.
Okay. Okay, thank you very much, Your Honor.
You're welcome, miss. The record should reflect that it's now 10:42 a.m. by the court's clock, and Mr. Parker still has failed to appear. We will be in recess. Good luck to you, Ms. Parker.
Thank you, Your Honor. Have a nice day.
You too, ma'am. Good luck to you.
I just text them to see if they could get prosecutor, because I told her 10 minutes and it's over 10 minutes.
I think we'll be able to. Yes, that's, we have a triangle. I called the very one. In the meantime, hopefully, if you have further questions. Can you call him back? I just want to make sure. Give her a specific time. Yeah, work it out with her. Okay. Thank you.
Calling the case of People versus Alexander James Johnston, file 21-006569-FC. Would counsel identify for the record, please?
Thank you, Your Honor. Caitlin York on behalf of the people.
Please, the court, Scott Moore for the defense.
Mr. Johnston, would you please stand and raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Could you tell us your name, sir?
Alexander James Johnston.
You may be seated if you'd like, Mr. Johnston. Are we proceeding on count one, unlawfully driving away of a motor vehicle, and also on habitual offender second offense notice?
Your Honor, I have not received an amended information. We are proceeding on an amended information.
There might be one being delivered as we speak.
Thank you. Yes, Your Honor, we are proceeding on count one, motor vehicle unlawful driving away, habitual offender third offense notice. The defense has received a copy of the amended information, we waive reading in open court, and will continue our waiver of preliminary examination.
Thank you, Mr. Moore. Mr. Johnston, do you understand that according to count one, you are charged with unlawful driving away of a motor vehicle?
Yes, sir.
Now, that crime is a felony, and ordinarily it would carry a maximum penalty of 5 years in prison, and the minimum sentence would be discretionary with the court, and your driver's license would be suspended or revoked by the Michigan Secretary of State. However, because do you also understand that you are charged as well with being a habitual offender third offense notice?
Yes, sir.
As a consequence, if you plead guilty both to count one, unlawfully driving away of a motor vehicle, and you also plead guilty to being a habitual offender third offense notice, the net effect of those things is that the court, in its discretion, could double the maximum penalty from 5 years in prison to 10 years in prison. It would be discretionary with the court whether or not to double the maximum end of the penalty or the maximum sentence. And regardless of whether the court did so, the minimum end of the sentence still would be discretionary with the court. You understand those things, sir?
Yes, sir.
Now, with regard to count one, unlawful driving away of a motor vehicle, and also with regard to being a habitual offender, third offense notice, you may make any of the following pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to count one, unlawful driving away of a motor vehicle, and to being a habitual offender, third offense notice, sir?
Yes, sir.
Then answering to count one, unlawful driving away of a motor vehicle, what is your plea?
Guilty.
And answering to being a habitual offender, third offense notice, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, sir.
The court also informs you that if your pleas of guilty are accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But on the other hand, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Johnston?
Yes, sir.
And do you understand that by pleading guilty to count one, unlawful driving away of a motor vehicle, and also pleading guilty to being a habitual offender, third offense notice, that means you will be giving up each and every one of those rights?
Yes, sir.
Now, sir, I'm going to ask your lawyer, Mr. Moore, and the assistant prosecuting attorney to tell us what the plea agreement is. And I want you to listen to both of them very carefully.
Okay.
Thank you, sir. What is the plea agreement, ma'am?
I believe the agreement, Your Honor, is a Briggs-Killebrew agreement of 8-month initial incarceration.
All right, and does it also encompass that the defendant would plead guilty to unlawful driving away of a motor vehicle and habitual offender third offense notice, and that after sentencing and passage of the applicable appeal period, the habitual offender fourth offense notice would be dismissed?
That's correct, Your Honor.
And then pursuant to People versus Briggs and Killebrew, there would be a sentence cap providing that the initial incarceration would not exceed 8 months in Clare County Jail.
That's correct, Your Honor.
And that agreement applies to initial incarceration and to no other term of sentence or probation.
That's correct, Your Honor.
Mr. Moore, is that your full and complete understanding of the plea agreement?
With the addition, Your Honor, that restitution is to be determined as by the Department of Corrections. What restitution is due and owing to the victim in this matter. Other than that, that is a full and complete statement of our plea. Thank you, Your Honor.
Thank you, sir. And with that clarification, ma'am, is that the people's understanding of the plea agreement as well?
Yes, Your Honor, thank you.
Thank you, ma'am. Mr. Johnston, did you hear what the assistant prosecuting attorney and your lawyer said the plea agreement is?
Yes, sir. 8-month Killebrew.
Well, that's part of it, but did you hear the plea agreement that was placed on the record, sir?
8-month cap where I would serve.
Sir, I'm not giving you a pop quiz. I'm not asking you to recite what the entire plea agreement is.
Oh.
I just am asking, did you hear what the plea agreement is that was put on the record?
Yes, sir, I did.
Did you understand the plea agreement that was put on the record?
Yes, sir.
And do you agree with that plea agreement?
Yes, sir.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, sir.
So for example, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or threatened your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty?
Yes,
And are
sir.
you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
Yes, sir.
Now, in light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
Then, sir, drawing your attention back about 4 months ago to January 4 of 2021, were you in the city of Clare in Clare County, Michigan?
Yes, sir.
On that day and at that location, were you driving a motor vehicle that belonged to another person?
Yes, sir.
And the motor vehicle you were driving, was that a 2003 GMC Yukon sports utility vehicle?
Yes, sir.
And did that vehicle belong to Arthur Eugene Knoll?
Yes, sir.
Did you have any permission? I think I mispronounced his name. Well, in any event, did you have any permission from Mr. Knoll or anyone else to drive that Yukon SUV?
No, sir.
But you went ahead and did so anyway, is that correct?
Yes, sir.
And drawing your attention to on or about February 10 of 2010, in the 29th Circuit Court for Gratiot County, Michigan, were you convicted of the felony crime of assaulting or resisting or obstructing a police officer?
Yes, sir.
And drawing your attention to on or about May 23rd of 2011, in the 29th Circuit Court for Gratiot County, Michigan, were you convicted of the felony crime of unlawfully driving away of a motor vehicle?
Yes, sir.
Mr. Moore, are you satisfied that there is a sufficient factual basis to accept the defendant's pleas of guilty to unlawfully driving away of a motor vehicle, count 1, and also to being a habitual offender, third offense notice?
Yes, Your Honor.
Ms. North, do you agree on behalf of the people?
Yes, Your Honor, thank you.
Thank you. Very well in this case. Oh, and Mr. Moore, if I asked you this already, I apologize. Has the court complied with the court rule in the taking of these two pleas?
Yes, Your Honor.
And on behalf of the people, do you agree, ma'am?
Yes, Your Honor.
Very well, in this case, the court has not agreed upon the possible pleas or the possible sentence with the defendant, the defense attorney, prosecuting attorney, or anyone else. The court is convinced that these pleas have been entered understandingly, knowingly, and voluntarily, and in compliance with the Michigan court rules. The pleas of guilty to count one, unlawfully driving away of a motor vehicle, and to being a habitual offender, third offense notice, are accepted and ordered entered on the records of the court. Sentencing will occur. Mr. McConnell, on behalf of the department, if I schedule, well, sentencing will occur on Monday, June 21, 2021 at 9 a.m. Bond is canceled and the case is adjourned to the date and time indicated. Now, in a moment, Mr. Johnston, we will be disengaging, but before that happens, the probation agent for the Clare County Circuit Court Probation Department and the Michigan Department of Corrections, Nate McConnell, will have some questions and instructions to give to you.
Okay.
Mr. McConnell.
Thank you, Your Honor. Mr. Johnston, is your address going to be 6867 Vistoryville Road in Sheridan?
I believe so. I would have to talk to my dad about it and confirm that I can move back in.
Okay, very good. You'll receive a PSI packet over to the jail. Fill that out completely, and your agent will be in contact with you to do the interview.
Okay.
That's all, Your Honor. Thank you.
Thank you, sir. Anything further on behalf of the people, ma'am?
No, Your Honor, thank you.
And on behalf, anything further on behalf of the defendant, Mr. Moore?
No, Your Honor, thank you.
Very well, then we'll be in recess. We'll see you back here in June, sir. Good
All
luck
right.
to you.
You're all set, sir.
Fifty-fifth Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated. Calling the case of Robert J. Maxwell versus Homeowners Insurance Company, file 21-900070-CK. Would counsel identify for the record, please?
Yes, good afternoon, Your Honor. Josh McFarland on behalf of the plaintiff.
Good afternoon, Your Honor. Paige Batchelder on behalf of Defendant Homeowners Insurance Company.
This matter is scheduled for, or will be scheduled for, a jury trial. Are the pleadings sufficient, Mr. McFarland?
Yes, Your Honor.
And do you agree, Ms. Batchelder?
I agree.
I would ask that you exchange your known exhibits and your known non-expert witnesses within 28 days, and the rest as they become known to you. And does the plaintiff expect to call any expert witnesses, Mr. McFarland?
None other than I think the plaintiff's treating doctors, I would ask to testify as experts. But I don't believe I'm going to have anybody else.
Would you be able to name your known expert witnesses within 28 days?
Yeah.
And do you need more time than that, Ms. Batchelder?
No, Your Honor, I would only ask that we reserve the right to have plaintiff examined for an IME at some point if we need it.
Very well. Right to a so-called independent medical exam is reserved. And Copies of any such report shall be provided to opposing counsel upon receipt. We'll leave discovery open as long as it does not interfere with the trial. And I would ask for trial briefs at least 14 days prior to trial. And similarly ask for proposed jury instructions and proposed verdict forms at least 14 days before trial. How long do you think it would take to try the case, Mr. McFarland?
I think 3 days in total should be sufficient.
Would you agree, Ms. Batchelder?
I agree.
And when is the earliest you'd be ready for case evaluation, Mr. McFarland? September, November, January?
Yeah, I think I could be ready by September, but I know that Ms. Batchelder kind of just got this file a couple months ago, so I'll defer to her.
You know, Your Honor, are we gonna facilitate? Are you ordering us to facilitate this matter?
Well, would you like an order for facilitation?
I'm not opposed to it. I guess my only concern would be if we went to case eval, I'd like to facilitate first, but if Mr. McFarland doesn't think we need to facilitate, and that's fine with me, I'm fine with September for case eval.
And Mr. McFarland, would you like the case to go to facilitation?
I think case evaluation is sufficient, Your Honor. I don't foresee a need for facilitation in this case.
That's fine with me.
All right, and Ms. Batchelder, would you like, I could schedule case evaluation, for example, no earlier than November. Would that give you enough time to be ready for case eval?
You know, Your Honor, I think September we'd be fine there as well. So if Mr. McFarland agrees, I think September is fine.
Okay. I don't guarantee that it will happen then, but we'll say no earlier than September. And that being the case, then are we looking at a trial no earlier than January or December or what?
Your Honor, my husband and I are recently expecting, and I will be on maternity leave at that point. So
Okay.
I would prefer a trial date after January if possible.
Okay, would February suffice or?
Is March available? I'm due in November, so I just want to make sure I have sufficient time.
Yeah, we'll say no earlier than March, and congratulations, ma'am.
Thank you very much.
All right, and if you need additional time, just let us know.
Thank you.
Thank you, ma'am. Have all of the claims been joined from the plaintiff's point of view, Mr. McFarland?
Yes, Your Honor.
And from the defendant's point of view, Ms. Batchelder?
Yes, Your Honor.
Very well, then, is there anything else you'd like in the pretrial order, Mr. McFarland
None for me, thank you.
or Ms. Batchelder?
Nothing for me either, thank you.
Thank you. Congratulations once again. I'm sure that will make Richard very, very happy. Thank you.
Yeah, he's already suggested he'll be the nanny, so we're. Thank you very much.
Thank you, ma'am. Thank you, sir.
Thank you.
Who have appeared at 1:45 PM, which was the original time, so thank you for doing that. What I would suggest we do is that we wait. You can either check back in at 2:15, or we can put you in the waiting room, and at 2:15, if Brian still has failed to appear, we'll go ahead with the motion hearing at that time.
Okay,
Thank you, ma'am.
you're welcome.
In the show cause matters, all of the show cause matters were scheduled to be heard today, Tuesday, May 11, either at 12 p.m. or 12:05 p.m. or 12:14 p.m. It's now 1:52 p.m. by the court's clock, going on 2 hours since each of these defendants were ordered to appear, and with the following exceptions, none of the defendants have appeared. So in each case where the defendant has failed to appear, the court will be issuing a bench warrant for that defendant's arrest for his or her alleged criminal contempt of court for failing to appear here today as previously ordered, and for his or her alleged civil contempt of court for allegedly failing to pay the court-ordered money in each file as previously ordered. In each case, bond will be a cash-only bond to be posted only in the defendant's own name. Calling the case of People versus Ronald James Rogel II, file 08-3353-FH. Mr. Rogel has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $1,100. Calling the case of People versus Bruce Edward Loper, file 08-3354-FH. Mr. Loper has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $2,200. Calling the case of People versus Dustin Allen Mowinski, file 09-3613-FC. Mr. Mowinski has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $5,000. Calling the case of People versus Wallace Eugene Robinson, file 10-4058-FH. Mr. Robinson has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,400. Calling the case of People versus Thomas Eugene Meyer, file 10-4059-FC. Mr. Meyer has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $2,600. Calling the case of People versus David Lee Creason, file 11-4125-FH. Mr. Creason has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,800. Calling the case of People versus Kyle James McKenzie, file 12-4502-FH. Mr. McKenzie has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $7,500. Calling the case of People versus Paul Ignacio Johnson, file 13-4672-FC. Mr. Johnson has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $3,000. We will return for a moment to the case of People versus Kyle James McKenzie, file 12-4502-FH. The court had erroneously indicated Mr. McKenzie failed to appear. In fact, Mr. McKenzie did appear and entered into an agreement whereby he will pay $100 at least by 4 p.m. on May 14, 2021, and continue making monthly payments of $100 per month beginning June 15, 2021, and each month thereafter until all of this money is paid. The court will not issue a bench warrant at this time regarding Mr. McKenzie. Calling the case of People versus Michael Jordan Rodriguez, file 13-4680-FH. Mr. Rodriguez has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $3,000. Regarding the case of People versus Kim J. Thomas, file 14-4870-FC. That matter will be scheduled for a show cause hearing in July of 2021. Calling the case of People versus Raymond Arthur Massey, file 14-4955-FH. Mr. Massey has entered into an agreement whereby he will pay $100 by May 15, 2021, and continue to make additional monthly payments of $100 per month beginning June 15, 2021 until paid in full. Should he fail to do so, the court will consider issuing a bench warrant for his arrest. Calling the case of People versus Nicholas Daniel Richards, file 15-4982-FH. Mr. Richards has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,700. Calling the case of People versus Andrew James Putnam, file 15-5155-FH. Mr. Putnam has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $3,750. Calling the case of People versus George Rasan Laufer, file 15-5180-FH. Mr. Lauder has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $500. Calling the case of People versus Joseph Lee Harris Jr., file 16-5325-FH. Mr. Harris did appear. He made a payment and will continue entered into a payment agreement whereby he will make payments of at least $25 per month beginning June 15, 2021, and each month thereafter until the amount that he owes is paid in full. Calling the case of People versus Stephen Bruce Morningstar Jr., file 16-5331-FH. Mr. Morningstar has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,500. Calling the case of People versus Rex Charles Rogers, file 16-5337-FH. Mr. Rogers has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,250. Calling the case of People versus Nicole Louise Swan, file 16-5367 FH. Ms. Swan has failed to appear. The court will issue a bench warrant for her arrest. Bond on the bench warrant is set in the amount of $900. Calling the case of People versus Lacey Amelia Strickland, file 17-5519 FH. Ms. Strickland has failed to appear. The court will issue a bench warrant for her arrest. Bond on that bench warrant is set in the amount of $1,250. $1,250. Calling the case of People versus James Ashley Stevens, file 17-5699 FH. Mr. Stevens has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $620. Calling the case of People versus Delon Holloway McGowan, file 17-5726 FH. Mr. McGowan has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $2,200. Calling the case of People versus Derek Allen Weartala, file 18-5830 FH. Mr. Weartala has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,500. Calling the case of People versus Gary Henry Chanel, file 18-5981 FH. Mr. Chanel has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $1,600. Calling the case of People versus Casey Allen Morgan, file 19-6118 FH. Mr. Morgan has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $2,250. $2,250. Calling the case of People versus Jeffrey Scott Jewell, file 19-6150 FH. Mr. Jewell has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $2,200. Calling the case of People versus Sean Kyle Richards, file 19-6158 FH. Mr. Richards has failed to appear. The court will issue a bench warrant for his arrest. Bond on that bench warrant is set in the amount of $2,200. Calling the case of People versus James Lee Bailey, file 07-3131 FH, and also file 09-3728 FH. Mr. Bailey has failed to appear in each of these two matters. The court will issue bench warrants for his arrest in each matter. Bond as to each of the bench warrants is set in the amount of $2,000 for a total of $4,000. Calling the cases of People versus Damian Joseph Carlton, file number 12-4467 FH, and file 13-4721 FH. Mr. Carlton has failed to appear in these two matters. The court will issue bench warrants for his arrest. Bond on the bench warrant in the 2012 case is set at $500. Bond in the 2013 case as to the bench warrant is set at $1,100. Calling the case of People versus Matthew Scott Hopkins, file 07-3247-FH. Mr. Hopkins has failed to appear. The court will issue a bench warrant for his arrest. Bond on the bench warrant in that matter is set at $2,000. In addition, Mr. Matthew Scott Hopkins also has failed to appear in file 07-3305-FH and in file 09-3812-FH. The court will issue bench warrants on all three of these files. As previously indicated, the bond in file 07-3247-FH is set in the amount of $2,000. In file 07-3305-FH, bond is set in the amount of $2,000. And in the 2009 file, bond also is set in the amount of $2,000. Calling the case of People versus David Charles Kemmerer, file 11-4277-FH and file 12-4521-FH. Mr. Kemmerer has failed to appear in each one of these two files. The court will issue a bench warrant for his arrest in each of the two files. Bond on the bench warrant in each of the two files is set at $1,500 for a total of $3,000. Calling the cases of People versus Chester M. Kristiniak III, files 07-3289-FH and file 07-3290-FH. Mr. Kristiniak has failed to appear in each of these two matters. The court will issue bench warrants for his arrest. Bond on the bench warrant in file 07-3289 is set at $1,600. Bond on the other file, file 07-3290-FH is set in the amount of $5,000. Calling the cases of People versus Donald Ralph Miracle, file numbers 18-5947-FH and 18-5948-FH. Mr. Miracle has failed to appear in these two files. The court will issue bench warrants for his arrest. Bond on the bench warrant in file 18-5947-FH is set at $2,200. Bond on the bench warrant in file 18-5948-FH is set in the amount of $400. Calling the two cases of People versus Zachary Lee Riggs, file 10-3904-FH and 10-3905-FH. Mr. Riggs has failed to appear in each one of these two files. The court will issue bench warrants for his arrest. Bond in file 10-3904-FH is set in the amount of $4,000. Bond in file 10-3905-FH is set in the amount of $1,200. Calling the cases of People versus Kyle James Wright, file 19-6129-FH and file 19-6274-FH. Mr. Wright has failed to appear in each one of these two files. The court will issue bench warrants for his arrest in each one of the two files. And the court sets bond in each one of the two files in the amount of $2,000 for a total of $4,000. Calling the cases of People versus Kenneth Joseph Young, file 15-4998-FH and file 15-5100-FH. Mr. Young has failed to appear in each of these two files. The court will issue bench warrants for his arrest. Bond on the bench warrant in file 15-4998-FH is set in the amount of $1,750. Bond on file 15-50, bond as to the bench warrant in file 15-5100-FH is set in the amount of $1,000. Once again, each one of these cases, bond is set in cash, as a cash bond to be posted only in the defendant's name. And in each one of these cases, the defendant has failed to appear, except as otherwise noted on the record. Each of the defendants was ordered to appear here more than an hour ago. It's now, actually, each of the defendants was ordered to appear here more than 2 hours ago. Each of the defendants was ordered to appear here at approximately 12 p.m. or 12:05 or 12:14 p.m. It's now 2:14 p.m. by the court's clock. At least 2 hours past the scheduled time for each of these defendants to have appeared, and except as indicated on the record previously, each of the above defendants has failed to appear. We'll be in recess then. Calling the case of Amanda Levesque versus Brian Levesque, file 21-900157-DO. Ms. Levesque, would you raise your right hand to be sworn, miss?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
You're right.
What, could you repeat that, ma'am?
There we go. Couldn't hear you, sorry.
Okay, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name?
Amanda Levesque.
Ms. Levesque, well, first, does Brian Levesque appear here today? The record should indicate no response. The record should indicate that Mr. Levesque had been ordered to appear here today at 2:15 p.m. for a hearing on the plaintiff's motion for alternate service. It's now 2:17 p.m. by the court's clock, and Mr. Levesque has failed to appear. What brings us into court is that back on April 7, 2021, the plaintiff, Amanda Levesque, filed a complaint for a divorce. And at that time, she also filed a motion for verification for alternate service, stating in support, quote, I have previously mailed Karen, registered Karen, divorce paper, no reply, and was returned. Divorce was dismissed. Brian has federal warrant for state of Michigan, close quote. Ms. Levesque, have you had any communication at all with Brian Levesque regarding
I have not.
regarding the divorce?
No.
When is the last time you had any communication with Brian?
I'm gonna say January of 2018.
Okay. And do you know where he is?
I pretty much think I do, but I can't say for sure.
Where is it that you think he is, ma'am?
Chickamauga, Georgia.
Okay. And have you communicated with the sheriff department in Chickamauga, Georgia, or any process server to try to have them serve a copy of the complaint on Brian?
I did talk to the sheriff's department down there. They actually have been looking for him because of the federal warrant, because Michigan wants him back. And they said they have not been able to locate him.
And why is it that you think he's in Chickamauga, Georgia?
Because that's where he was the last 8 years that we were together, and he was staying at a hotel. And every time a sheriff's department deputy would show up, he would have somebody else answer the door.
All right. You have said, in essence, I would like to be authorized to have alternate service on Brian. What is the alternate service that you want to accomplish, ma'am?
There's a paper that I know he reads every day, and that's the Walker County Messenger, and I'd like to put it in the paper down there.
Is Chickamauga, Georgia in Walker County?
Yeah.
All right. And is this a weekly paper or a daily paper?
Yeah. It's a weekly paper.
All right. And you would be putting it in this. Very well, then I will authorize alternate service by you publishing notice in the, did you say Walker County?
Yep, Messenger.
The Walker County Messenger newspaper for 3 consecutive weeks. Yeah, notifying Mr. Levesque that he is being sued for divorce by you in Clare County, Michigan. And I would ask you to put in that notice the file number 2, which is file 21-900157-DO, and notify him in that notice that he must file an answer. How long do you think it will take you to publish this, Miss?
I'll get on it today.
All right, so do you think you'd be able to have it in the newspaper within a month?
Oh, yeah.
All right, then you have them put in the notice that he must file an answer to this complaint for divorce by August 11, 2021.
Okay.
Thank you, ma'am. That would be 3 months from today, August 11. Thank you, miss.
Okay. Thank you.
You're welcome, and good luck to you, ma'am.
Thank you. Bye.
Bye. You can disengage if you would like. Thomas Quentin Moore versus Heather Wanda Grosser, file 21-900-106-PP, would counsel identify, would counsel identify for the record, please?
Your Honor, Isaac Coast for Ms. Heather Grosser.
Does Thomas Quentin Moore appear? The record should indicate no response. The record should also indicate this matter was scheduled for hearing at 2 p.m. today. It's now 2:24 p.m. by the court's clock, and Mr. Thomas Quentin Moore still has failed to appear. There is a certificate of mailing in the file indicating that the court's assignment clerk, Annette Mead, certified that each of the above parties, being Thomas Quentin Moore at 8538 Haskell Lake Road in Marion, Michigan, and the respondent's attorney, Isaac J. Post, at 195 South Main Street in Harrison, Michigan, were served notice of today's hearing. It's now 2:25 p.m. by the court's clock, and Mr. Moore still has failed to appear. What brings us into court today is that back on March 15 of 2021, the petitioner, Thomas Quentin Moore, filed a petition seeking a personal protection order in a domestic relationship against Heather Wanda Grosser, and he sought entry of a personal protection order on an ex parte basis. Later that same day, March 15, 2021, the court issued a personal protection order against Ms. Grosser, prohibiting her from doing certain things, especially with regard to Thomas Quentin Moore. And that personal protection order was scheduled or slated to remain in effect for a period of 2 years until 11:59 p.m. on March 15 of 2023. Thereafter, the respondent, Heather Wanda Grosser, filed a motion to terminate the personal protection order. That motion was filed on March 24, 2021, with a stated reason, quote, Thomas assaulted me on Saturday, March 6, 2021. The police were called. Thomas is facing a domestic violence charge, possibly also a felony for strangulation. I tried to get a PPO after this assault and it was denied. There is currently a no contact order as part of his. This was retaliation to punish me for seeking help after an assault. I'm sorry, I left out a word. The second to the last sentence reads, there is currently a no contact order as part of his bond. Then the final sentence reads, this was retaliation to punish me for seeking help after an assault. And that was quoting from the motion to terminate the PPO or personal protection order that the respondent, Heather Grosser, filed with the court back on March 24, 2021. The hearing on that motion originally was scheduled to be heard on Thursday, April 8, 2021. On April 5th, Attorney Isaac Post filed his appearance on behalf of the respondent, Heather Grosser, and apparently the hearing did not take place on April 8th, but was scheduled to be heard today. And so it's the court's understanding we're proceeding today on the respondent, Heather Grosser's motion to terminate the personal protection order, and that it was postponed from April 8th until today at the request of her attorney, Isaac Post. Is that correct, Mr. Post?
That's correct, Your Honor.
All right, it's approximately 1/2 hour after the scheduled time for the hearing. It's 2:29 p.m. by the court's clock. Mr. Moore has failed to appear. How would you like to proceed, Mr. Post?
Your Honor, so, and I could be wrong about procedurally what is necessary, but my understanding is even though it's our motion, the burden shifts back to the petitioner since it was an ex parte order, and that it would be his burden to prove the necessity for the personal protection order.
I believe that's a correct assertion of the law. I think the burden of moving forward as to the motion itself is on the respondent, the moving party, but that once she does move forward, that the burden then would shift over to Thomas Quentin Moore, the petitioner, to show cause that he still needs a personal protection order. And do you wish to present any testimony from Heather Grosser, or do you want to have the court address this matter on the basis of Mr. Moore's failure to appear here today, Mr. Post?
Well, Your Honor, I certainly could have my client testify, and I will if the court thinks it's necessary to hear some evidence to revoke or terminate the personal protection order. But I don't want to unduly burden the court with unnecessary testimony. So that's why I wanted to make sure that the burden shifted back to the petitioner, and without the petitioner, I don't think that he's met his burden. But again, Your Honor, I don't want to just rest and then say, oh, well, Isaac, you lose. And so I don't think he's met his burden, Your Honor.
Very well. The court's understanding of the law is that the burden, the respondent has filed a motion to terminate the personal protection order. She has appeared here today in a timely manner, ready and able to testify. She is prepared to move forward. The burden now shifts to the petitioner to show cause that A, he even wants the PPO to remain in effect, and B, that there's a need for the personal protection order to remain in effect. Mr. Moore has failed to appear here today. He has failed to meet that burden. It's now 2:33 p.m. by the court's clock. He still has failed to appear. Accordingly, the court will grant the respondent's motion to terminate the personal protection order, and I will sign an order to that effect. Will you prepare that order, Mr. Post?
Yes, Your Honor, I'm happy to prepare that order.
Okay, thank you, sir. And good luck to you, Ms. Grosser. Thank you for being here today. It's now 2:34 p.m. Thank you, ma'am. and the respondent still has failed to appear.
And Heather, I think the judge is done with us. If you want to call my office, then I'll explain everything.
I sure will. Thank you, Isaac.
Okay, thank you, Your Honor.
Thank you, Isaac, and thank you, Ms. Grosser. We'll be in this.